Our next speaker will be my other colleague, Professor Alex Locke. And he's a professor at City University of Hong Kong, and he's also the director of the Business Law Center here. He's an expert in the common law in Singapore, in Hong Kong, and in all the common law systems. So so Alex, it's your turn.
My research area is on commercial law, and in particular, my interest is on the common law. So this invitation gave me a chance to explore some of the issues that are involved when we move from the sale of goods kind of regime. In Hong Kong, we call it the SGO, or I prefer to call it SOGO because it's easy to pronounce, to the CISG regime. What is different about the CISG regime? And if I'm speaking to a more layman audience, I will lay out some of these differences, but seeing that many of you here are experts, I do not need to do so in any great detail. I'll just mention that to those who are used to the SOGO regime, this idea of notification, for example, is quite foreign. The notion of a right to cure is quite foreign. And the other things which look quite similar, but they're actually quite different. So for example, there's something which looks quite similar to frustration, but if you look at it more carefully, you find that it operates differently from frustration in the common law, because what the provision does in the CISG is to relieve you from liability, but it doesn't quite terminate the agreement for you. So, which means that if you have a party who wishes to argue that the supervening event has resulted in a termination of the agreement, you can't quite use that provision. You need to use something else in addition to that provision before you can get to the outcome which you want, which is to terminate the agreement. And one of the bigger paradigm shifts that the lawyer must have, and here I refer to both the transactional lawyer as well as the litigation lawyer, is actually this. That when we move from the SOGO regime to the CISG regime, one of the paradigms which we are so used to, which is this paradigm which involves the division of terms into conditions, warranties, and nominate terms, just doesn't quite exist in the CISG. Now, this is of some interest, especially when we talk about international sales, because as many of you know, international sales, many of these international sales involve the tender of documents, right? The tender of documents. So my interest in this presentation is to ask, when we move from the SOGO regime to the CISG regime, how much of the refitting, how much of the review, and how much of the revision does one need to make to the standard form contracts which are currently used in Hong Kong? And if one is kind of willing to move into the CIG regime, how much of refitting or revision is necessary? So that's the nature of my interest, right? The particular context I'm interested in is international sales, and more particular than that is international sales which normally have some dimension of a documentary tender. So maybe we can talk about some other related things that have been floated in the course of the last few presentations. One of the things which I want to just pick up, and this has nothing to do with my presentation, is this idea of cross-fertilization, the notion of whether a regime like the CISG might actually cross-fertilize and give ideas to the way that to the reform or the development of one's own legal system. And so, as I said, this has nothing to do with my presentation here. But on that matter, I'm a little bit pessimistic. And then we've got some examples of that to prove. One is exactly what Professor Zeller has talked about in his presentation, which is that the courts don't seem to know enough about the CISG, or maybe lawyers didn't know enough to present to the courts how the dispute should be resolved. But even a jurisdiction like Singapore, which has which prides himself with having an international commercial court, you find that this kind of cross-fertilization hasn't quite taken place. You can just help me with what you want, right? And I just give you two examples of it. One of them refers to the parole evidence rule. And as was mentioned earlier on, the CISG allows for the admission of all evidence that was all that was said in the course of the time leading up to the conclusion of the agreement. Is it okay? Yeah, okay. And so you would have thought that that would also go into the conscience of the Singapore courts. But in my conversations with Professor Gary Bell, that seems not to have seeped in at all into the conscience of the Singapore courts. The other one, which comes up more implicitly, is in the area of implied terms and interpretation. Now, the common lawyers were at one point in time very intrigued, I think that's putting it very lightly, with a notion that was floated by Lord Hoffman, where in the case of AG and Belize, he said that, oh, well, maybe we should actually see the implication of terms as mere interpretation, right? We should merely see the implication of terms as mere interpretation. Now, that set off a firestorm of protests from the common lawyers. And in Singapore, and actually the Court of Appeal came up very strongly to say that we will do no such thing. Implication involves a process which is quite distinct from interpretation, all right? And so we keep those two processes distinct. And even in the UK, that notion has now been expunged in the Marks and Spencer case. But dealing with a bit of comparative law, you find that this notion of looking at implication of terms as interpretation is actually not that unusual after all. After all, in Germany, that's the way they do it. In some ways, therefore, if you look at Article 8, right, and Article 8 and 7 of the CIS, what you have here is actually nothing, no mention of implication of terms at all. Everything is subsumed under interpretation. And so if one wants to kind of approach the CISG by asking implied terms, the question which arises is, well, do we use the common law technique for application of terms, or do we use the CIS method, which is to go through interpretation, right, to find what is the extent or the contours of the agreement. So, but what I want to say here is that if this notion, right, of cross-fertilization of ideas had been successful, at least in Singapore, you would not find such a ready rejection of this notion that interpretation is a very, very distinct process from implication of terms, and that you have some engagement, at least with the possibility that that because of this, perhaps the Singapore common law system should consider this possibility. I'm not sure where the student assistant is. He seems to have given up too on incorporating my slides into so that you can see them. Liu Xiao, shall I just carry on then with the rest of my presentation?
Yeah, sure. Just to carry on, it seems we can't do anything about it. So it's big enough now. So I think you can.
Okay. All right. So going back to my presentation, which is about traversing these different paradigms and the transitional costs, if you wish, involved in doing this paradigm shift. I'm looking at this notion of what allows you to terminate the contract, right? In the common law, we are very used to this division of your terms of contract into conditions, warranties, innominate terms. Very simply, a condition will always allow you to, a condition in its full legal sense will give you two rights, the right to damages as well as the right to termination. And if the goods are not compliant, then if it also amounts to a condition, but it's before the time, the expiration time for performance, then you can reject the goods, right? Now, so that's quite clear. So it's based on classification of terms. And then there's also the innominate term, where the question whether you have a right to terminate the agreement depends on the consequence, and more particularly, there must be serious consequences before you are entitled to terminate the contract. Now, because of the history of the common law, many of the terms have already been classified by case law, by precedent, into conditions or warranties, and some into innominate terms. So there is a, shall we say, a huge reservoir, all right, of knowledge, which the parties can draw upon when they draft their agreements. Now, when we move into the CISG regime, now, I seem to be having a problem. Okay, right, that's great. So when you move into the CISG regime, you find that there is actually no such division of terms into conditions, warranties, or innominate terms. The question whether you have an entitlement to terminate a contract is basically decided by Article 25. And this looks familiar enough, all right? So everything now channels into looking at this, whether there are serious consequences or not. But that is not the only criteria. It must also be this serious consequence must also be foreseeable under Article 25. So when you move, therefore, from the SOGO regime into the CISG regime, the transactional lawyer who is going to review and refit the contract for the new scenario has to bear in mind that there is no such notion, right, of condition, right? So if you leave it to the CIS regime, then everything is decided by reason of the serious consequences or not serious consequence of the breach. Now, as has been pointed out in earlier presentations, the notion of party autonomy is very important in the CIS. So Article 6 allows one to either exclude the application of the convention altogether or to vary any of these provisions, right? Now, so if one parties desire to use their former terms, right, which were designated as conditions, as continuing to apply as such so that they have a right to termination, they now will need under the CIS regime to more clearly stipulate that a non-compliance of the term amounts to a fundamental breach under Article 25 of CIS. Alternatively, just go straight to the issue. Just say that the non-compliance with this term, the non-performance of this term, the breach of this term, all right, allows the innocent party to avoid or to terminate the agreement and to damages, right? So the CIS Article 6 therefore allows contracting parties to choose, right, the kinds of terms which will give them a right to termination, regardless of the consequence, by mere designation that one is permitted to terminate the contract upon proof of breach. Now, so and this matter about exact compliance is actually a matter which is quite foundational when you're talking about international documentary sales. And here the keyword is on international documentary sales, where essentially the seller puts his goods upon a vessel, right? The master of the vessel provides to the seller a bill of lading. So this is the document of title, which he then tenders to the buyer. And in return for this tender, the buyer will have to pay. So this will be the documentary sales that we're talking about. You may not have received the actual goods yet, but you pay against the documents. All right. So this slide here paints for us a bilateral kind of scenario involving just a buyer and seller, but where the obligation to pay is contingent upon the tender of documents. So the situation, of course, in the real world gets a bit more complicated because what you have in the real world is, apart from these kind of string contracts, you also have cases, you also very often have banks coming into the picture. So I'll come to that very, very soon. But let's go back to this. Now, so the assurance of payment against the proper tender of documents is therefore something which is accepted as being as something of great importance. In the common law, this was well accepted, and this is just one of the cases which illustrates the matter. In this case of the re-general trading, what you have are goods which are unproblematic. What you have is a contractual stipulation which says that the goods must be shipped by January. Unfortunately, the shipping document said February. In fact, the shipping documents were wrong. The goods were actually placed on board the ship in January. Nonetheless, because of the erroneous statement on shipping documents, the buyer was entitled to reject these goods, right? Now, so what you have, therefore, is a strong principle, strong principle of strict compliance. Now, this is said to be important because this is how the market operates, right? When you sell from A to B to C to D, what the parties have are goods which are in transit, and all they have are the documents which they tender down the string, right? And they are able to get payment when they tender perfectly compliant documents. This, therefore, is the notion of the clean documents, which give you that right to payment. Okay. The understanding here is that parties view by documents, and more importantly, once you have clean documents, you have entitlement to payment. Now, as I said earlier on, the situation in the world, of course, gets more complicated. It involves banks too. Credit comes in, and here is where you have the buyer telling a bank, all right, that to open a letter of credit in favor of the seller, and for the bank to accept the documents and give payment. Now, this therefore gives international parties the assurance of payment because the bank is seen to be a honest broker. And once the documents are compliant, they will pay against the documents, right? So you have first, what you saw in the earlier slide was a string agreement, all right, involving merely buyers and sellers. But upon this is also another system which involves the financing of the international sale of goods, and this is where the banks get involved. And again, what you have here are transactions which are actually based and premised upon exact compliance with what the contract entails. Now, the question, all right, which documentary lawyers have to kind of deal with when Hong Kong moves from a SOGO-based regime to a CIS-based regime is this: do the parties have to expressly stipulate that the documents tendered must strictly comply with the contractual stipulations? In other words, is it necessary for an express agreement that any defect in the documents amount to fundamental breach? Now, this is therefore a very fundamental operating axiom in the Hong Kong system right now. All right. Now, so when we move into the CIS system, do I, as a transactional lawyer, have to refit all these documents to say that, hey, you exact compliance with what we stipulate as compliant documents is necessary? If anything is wrong with it, let's just say the date of shipping, or whether it's a clean bill of lading, then I'm not required to pay. Now, the good news is actually this, that in the process of writing up the CISG, the Secretary did acknowledge this, right? And the commentators also acknowledge that when we talk about documentary sales, there is this very strong norm of strict compliance. So if you look at many of the commentaries on this, in particular, Shek Trim Insurance, you'll find that they take the view that when it comes to documentary sales, it is accepted usage, right, in international trade. So that's under Articles 9.2, that the norm of strict compliance applies to documentary sales. So Article 9.2 talks about accepted usage in international trade, and if you're able to prove in international trade, the norm is of strict compliance when it comes to documentary sales, you're entitled to expect that all documents are strictly compliant with the contract, or else you don't pay, right? Then that becomes part of the usage that goes into your contract. Okay. Now, the other argument which also furthers this is actually the relevance of usage in interpreting parties' intentions, which is found in Article 8.2 and 8.3. And insofar as parties are in a particular kind of industry, there's a usage which is set to apply to their contracts, and that will be used to interpret what they actually mean when they say CIF, for example. Now, and adding on to this, once you employ some of these standard terms in international trade, say FOB or CIF, especially if you put it in Incoterms, right? What it actually happens is that one incorporates the entire regime that you find in the Incoterms relating to CIF or FOB as the case may be, where it is accepted that documents have to strictly comply with what is stipulated. In other words, if there's no strict compliance, you do not pay against the documents. And this is reinforced by the UCP, which is UCP 600, which all the banks incorporate into the agreements and also into the letter of credit when they open letter of credit in favor of the seller. UCP again contemplates that the documents have to be strictly compliant with the contract. Now, what all this means is that by reason of the history of how this CIS was drafted, by reason of the Articles 9, Articles 8, as well as incorporation, and seems to be the consensus of commentators, is that insofar as you're talking about documentary sales, it will appear that your documents need to be strictly compliant with the agreement, and that in effect therefore takes it out from Article 25. Now, question, what happens if there's no defect in the documents? So all this while we've been talking about documents which need to be strictly compliant with the contract. What happens if that in this scenario where the defect is not in the documents but in the goods? And this is where transaction orders need to be much more careful about, because insofar as we have got strict compliance regime applying to the documents, it doesn't quite apply to goods. So if you're talking about the goods per se, when one receives the goods and you find that they're non-compliant with the contractual description, all right, or something has gone wrong with the goods, then you can't revert to your strict compliance regime, because your starting point is actually now Article 25 of CIS. So if you want to have the right to reject or the right to terminate for non-compliance, then one has to stipulate for that in the agreement. Okay. Now, where there is no defect in the documents, all right, but the defect in the goods is evident from the documents tendered, right? So this is an interesting scenario where the defect in the goods is evident from the documents tendered. For example, the grade A or grade B kind of soybean, right? Then the question is whether one can squeeze a non-compliance as amounting to a non-compliance with a documentary requirement. If that is so, then you have the strict compliance regime applying to you. Otherwise, then you have Article 25 applying to you, right? Which again accentuates the importance of expressly stipulating for your right to termination. As to other kinds of obligations relating to shipment, for example, notification of when the ship is ready to load, like what one sees in the bunch and tradex kind of scenario. The starting point is back to the fundamental breach requirement that you see in Article 25, but one can make use of the party autonomy principle in Article 6 to stipulate expressly that one has a right to terminate if there is a breach of such an obligation. Now, what this means, therefore, is the transactional lawyer who is trying to refit, review, or recast these documents as one moves from the SOGO regime to the CIS regime has got to have it very clear in his mind. Are we talking about documentary-based obligations? Are we talking about other kinds of obligations? Insofar as we're talking about documents-based obligations, I think they are on fairly safe ground, even if there may be no express stipulation, because I think from the history of the CIS, from the comments of the commentators, right, you would find that this norm of strict compliance would nicely apply to documents. So the notion there of clean documents, as well as the notion that the time for tender of documents must be strictly complied with. But insofar as we are talking about other kinds of obligations, then we are outside this norm of strict compliance. If one wants, therefore, to provide for a right of stipulation, right of termination, that has to be expressly done. All right. So this, I think, is the burden that comes to the transactional lawyers as their clients move, as Hong Kong organizations move from SOGO into CIS. Now, in the Peter's presentation much earlier on, and also in Gary's presentation, they mentioned that lawyers may jolly well just advise their clients to exclude the CIS altogether. And this is a comment which, this is something which I allude to. I know the time is up. Let me just finish up in 2 minutes, okay?
Yeah.
Yeah. So this is something which I think is a very real problem, especially in today's world where we're having an economic crisis going on. The cheapest way of dealing with the transition from SOGO into CIS is actually to exclude a CIS altogether until one has time to look at it. But the problem with that, as you see from the presentation of Gary is this: the organizations may never really come to it, right? Now, so I think in my response to the DOJ, I said that this gives an opportunity for us as education institutions in Hong Kong to introduce, right, the learning of the CISG into the curriculum, whether it's in the law school curriculum or the business school curriculum. This, I think, will avoid some of the problems that Professor Zeller talked about along in his presentation, where the professionals who have supposed to deal with CISG do not know enough about it. But I think in totality, as I've said to the DOJ, I think this move to adopt the CISG to apply to Hong Kong is something to be very much welcome, because I think it increases the sophistication of the Hong Kong system in international trade. So thank you very much.